Right from the opening question, this courtroom is in verification mode. Judges don't waste time here. Identity confirmation sets the legal tone, and once that's locked in, things move fast. Watch closely how procedural this gets.
Good morning. Are you William Mallett?
Yes, ma'am.
And so Mr. Mallett was previously in court, entered a plea of guilty to obstruction or retaliation. Before we go forward, I got a pre-sentence report done, and I've reviewed that.
This moment matters more than it sounds. The judge is separating felony exposure from misdemeanor risk. That distinction can mean the difference between probation and prison. If you're wondering, yes, jurisdiction here is everything.
What's the status of, it shows there's a pending criminal mischief and evading arrest or detention?
So those should be under the misdemeanor.
Okay.
Cases that he does still have pending, so those be taken care of in misdemeanor court.
Okay, that's what I thought. I just wanted to
Yes, ma'am.
make sure we weren't looking at something else. Okay.
As far as I know, we don't have any other felony charges.
No reason not to go forward with sentencing.
Correct, Judge.
And so have both of you had an opportunity to review the pre-sentence report?
Yes,
We
Your
have,
Honor.
yes, Your Honor.
All right, any additions or corrections?
No, Your Honor.
Judge, just more of a suggestion.
This is a deferred adjudication, one of the biggest legal lifelines a defendant can get. No conviction yet, but it's a tightrope walk. One misstep on probation, and this deal collapses instantly.
And I just want to make sure that his mental health issues are addressed in probation. I think that's going to happen. I just want to make sure I put that out there.
I will. Thank you so much for pointing it out again also. Mr. Mallett, I'm going to find that you entered your plea of guilty previously freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 4 years. You're ordered to pay a $300 fine and to follow all of the rules and conditions of probation. I am going to recommend that Mr. Mallett be at least...
Listen carefully. This is the probation trap judges always explain clearly. Follow every rule, and the felony disappears. Violate even one condition, and suddenly you're staring at up to 10 years in prison. No rewind button?
It looks like it's already the recommendation that he's on the high need caseload with Spindletop, and so we're going to get you whatever help you need to be able to be successful. But it's important that you take advantage of that, okay? So if you have appointments, you have to go to them. If medicine is recommended, you need to take medicine. Whatever it is to make you able to be successful on this probation, we're going to give you those tools through probation, but you have to ask for those things, okay? Do you understand?
Yeah.
Okay. All right. And so if you do everything that you're supposed to on this probation, then this is a great opportunity because you don't have a felony conviction. At the end of the probation period, if you're successful, the case will be dismissed. You'll never be a felony, have a conviction on your record. The other side of that, though, is if you do violate any condition of probation, you can be brought back into court. You could be found guilty of the offense, and you could go to prison for between 2 years and up to 10 years. Do you understand?
Yes, ma'am.
All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. If you'll just go back with the bailiff probation, we'll talk to you today to give you your instructions so that you know what to do when you're released from jail, okay? And then I don't know if he has bonded out on those. Maybe you guys can request that he get those.
Now the courtroom energy shifts completely. New defendant, new stakes, and these are no longer probation-level consequences. Prior convictions change everything in sentencing.
Taking care of this on their jail runs this week.
Okay, I'll check to see if they have them on the packet.
Okay.
If not, could you see?
Just indicted last weck, so that's why it may not show.
Oh.
I did like the work on it, sir.
All right, sir, you're David Greer. Speak up for me, please. Thank you. And will your client waive the formal reading of the indictment in each case?
So is.
Judge, on the state jail, the 26 cause number, may we proceed just on count 1, but with the 2 bullet points that make the misdemeanor state jail.
Yes, ma'am.
No objection.
Thank you. Cool. Bless you. Okay. So, Mr. Greer, in cause number 26, DCCR 0150, you're charged, the state has elected to proceed on count 1 only. It alleges that you committed the state jail felony offense of evading arrest or detention with previous conviction, and that's from October 2nd of 2025. It alleges that you were previously convicted of evading arrest or detention February 11th of 2021. And how do you plead to that charge? And are you pleading guilty freely and voluntarily? And is that prior conviction for evading true? Get this one done, then I can get to the next one. And then let me find the other one. Sorry, give me just a second. They're not in order on here, and so I'm having to find them because I think they might be under. No. There they are.
I can't fix that.
Sorry, y'all. Go paperless, they said. Okay, now in cause number 24, DCCR 2220, you're charged with the third-degree felony offense of unlawful possession of a firearm by a felon, and that's from August 24th of 2024. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? Speak up, please. And then finally, in cause number 25, DCCR 0324, you're charged with the third-degree felony offense of unlawful possession of a firearm by a felon from January 27th of 2025. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily? And because you actually did what they charged you with? In all three of these cases, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kimler?
Yes.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreements that you've made with the district attorney's office, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1 in each case.
Without objection.
It's admitted in each case. Is there any evidence that Mr. Greer is not competent?
None that I've observed, Your Honor.
All right, sir, in each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily, find that you're mentally competent, and you understand the nature and the consequences of those pleas. Give me just a second to get caught up here. In cause number 26, DCCR 0150, sorry. Find sufficient evidence to find you guilty, and at this time, find you guilty of the state jail felony offense of evading arrest or detention with a previous conviction.
This is where the math of justice gets real. Concurrent sentences mean time runs together, not stacked. But don't get it twisted. 5 years is still 5 years. And the firearm warning, That's the judge drawing a final hard line.
Sentence you in accordance with your agreement to a term of 2 years in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 24, DCCR 2220, also find that you entered that plea freely and voluntarily, find sufficient evidence to find you guilty, and at this time find you guilty of unlawful possession of a firearm by a felon. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you